Welcome to our first lecture regarding disability discrimination. Let's begin. So here are the topics that we'll be covering in this module. We're going to discuss in this lecture kind of an introduction, the prima facie case, and we're going to cover key ADA concepts. So let's begin. Disability discrimination has been with us, I guess, probably for all of human history. It was the last category of disability that was addressed through its own statute. But even with the Americans Disabilities Act, which is our primary statute that we'll be talking about in this module, there continue to be significant barriers to the employment and advancement of people with disabilities. This isn't a small group of people. There are more people with disabilities than there are in many of the other categories that we've talked about. This is something that can affect anyone, obviously, in any category. And we all might, even if we don't have one today, we might develop a disability, or we might have a family member with disability. So this is a topic that affects all of us potentially. The goal of the laws that we'll be seeing is for employers to be what we're going to call disability blind, which is kind of an ironic expression. The goal is that when we are evaluating candidates for a position, we don't look at what they can't do, but we look at what they can do in terms of their work output. And so that is the focus we'll see as we go forward. I said that the Americans Disabilities Act is the primary focus of this particular module, and that is true, but we have a secondary law that we'll be talking about sometimes as well. And that's called the Rehabilitation Act. You don't need to know the year of the Rehabilitation Act, but I think it's helpful in terms of the advancement of this particular law. The Rehabilitation Act was designed to give people with disabilities, at that time, early 1970s, the preferred term was handicapped. Nowadays, the preferred term is disability. But we'll be using both of those terms because one statute uses handicap and one statute uses disability. So we can see that this law passed not too long after the Age Discrimination and Employment Law passed. But unlike Title VII and the Age Discrimination and Employment Law, this particular statute was just focused on federal government employment and employment by a federal contractor. In other words, a private entity that has entered into a contract with the federal government. So it had a smaller scope. I think the logic here was, let's see how this law works with a smaller group of employers. And if it's successful, of course, we can always expand it. If it isn't successful, we can repeal it. Because there were concerns about, well, how would disabled individuals, or in fact then handicapped individuals, be able to maneuver in the workplace? Would this just be a chaotic situation? And so it was just kind of the dry run. The part of the Rehabilitation Act that we're focusing on is Section 503. So if you don't have this in your Quizlet, please go ahead and add it. And Section 503 is the section that discusses a discrimination based upon disability in terms of employment, the recruiting, the hiring, and training of disabled workers. So this is a kind of equivalent to Title VII. In other words, it's a part of a larger law that deals with other issues, but this is the section that deals with employment. So this is the one that we're interested in for this case. Again, we see that term covered employers. This is a common term that we see in many of these statutes. Of course, the definition of what is considered a covered employer differs from statute to statute. We've seen in Title VII that it mainly covers employers that have at least 15 employees. We saw in the Age Discrimination and Employment Act that the threshold was 20 employees. And here with the Rehabilitation Act, we see that the number is even much smaller. It's going to include federal contractors and the federal government. It doesn't include most private employers because most of private employers are not federal contractors. When the Americans Disabilities Act was ultimately passed in 1990, we'll see that the scope of the law was significantly greater than the Rehabilitation Act. In other words, Congress decided, yeah, this law works. And, we've given it, gosh, I guess 17 years of experimentation, and we've concluded that it makes sense to expand it to a larger pool of employees and employers. Now, the Rehabilitation Act did not require that potential plaintiffs file a charge of discrimination. In other words, there was no need to get a right to sue letter or to exhaust administrative remedies. We'll see, though, under the ADA that requirement does exist. So we do need to see an EEOC charge with the ADA. Now, going forward, we're going to talk about the Rehabilitation Act from time to time, but our primary focus is going to be ADA. So I'm not going to continually make these distinctions, but this is just one distinction that is important to be aware of. Again, our primary focus in this class is private employment, and most private employers are covered by the ADA, not the Rehabilitation Act. Another difference between the Rehabilitation Act and the ADA is a longer statutory period that plaintiffs have to file their lawsuit. So one of the reasons that the Rehabilitation Act continues to be of importance to us, well, one reason is that the federal government and federal contractors are still covered by it, so it would have importance even for that reason alone. But probably the greater reason is that much of the case law that developed over those 17 years has been applied to the Americans Disabilities Act. And so we'll see that even though the terminology is somewhat different from one statute to another, the courts have taken the case law from the Rehabilitation Act and applied it to the ADA. That's probably less important now because we've had 30 years or more of Americans Disabilities Act, but still those first 17 years for the Rehabilitation Act were a very important period in the development of the law, and so certainly legal scholars often do look to the Rehabilitation Act for interpretation of the ADA. So here we have our next statute. If you don't already have this in your Quizlet, please add it. And again, this just is going to extend the categories of protection to basically private sector employers. And just like Title VII, our threshold is going to be 15 or more employees. So this isn't going to capture the very smallest employers that only have 14 or fewer employees, but it's going to capture the vast majority of larger employers. We're going to see that state law can be different, not Texas state law, but other states can have different thresholds. So if you move to another state or you deal with an employer that is acting in more than one state, you might find that the threshold is different. One of the things I guess that was most controversial about the ADA when it was passed was that psychiatric disabilities were covered. There were lots of concerns about covering psychiatric disabilities, but they remain a very important source of protection for individuals, and they remain it remains the case that a significant number of the charges filed relate to psychiatric issues. So just like the Rehabilitation Act covered things other than employment, so we need to focus on 504, the Americans Disabilities Act covered categories other than employment as well. For us, we care about Title I. This is the title that applies to the employment situation. You will in your career very possibly hear about Title II situations. A lot of times these have to do with public accommodations. For example, if you are Jerry Jones and you are designing your football stadium, you have to make sure that you comply with Title II because that provides rules about how many elevators you need to have, how many handicapped parking spaces you need to have, what aisle widths need to be, things along those lines. So it doesn't deal with the employment situation. It deals typically with customers or the general public. That's not the focus of this particular session. Obviously, there's lots of carryover between one category and the other. Labor and employment, legal professionals are typically just handle Title I. Other legal professionals do Title II. We'll see more about this terminology going forward, but of course, as we've seen in others, particular in Title VII and the Age Discrimination Employment Act, is the only people who can successfully advance claims under this law are qualified individuals. So if I don't have a medical degree, I can't apply well, I can apply, but I can't successfully advance a charge of discrimination because I wasn't hired to be a doctor. Even though there was a doctor opening. The hospital hired a doctor, and that doctor perhaps wasn't disabled, but I won't have a successful claim under those circumstances because I wasn't qualified for the job. Now, perhaps the reason I'm not qualified is that I have a disability. Well, you need to be qualified in order to be eligible. And the reason that you're not qualified, disability or some other issue, isn't really relevant. So this is an early threshold that has to be crossed. So when we say qualify, we mean that the person has the necessary skills, experience, education, credentials to do that position. And we can see it says with or without reasonable accommodation. So irrespective of the need for reasonable accommodation. So if the only thing that's interfering with me being qualified is a lack of a reasonable accommodation, then the employer has to say, well, let's imagine that we add that reasonable accommodation into that situation. Well, then I become a qualified person. So we need to consider reasonable accommodations if they apply in that circumstance. One thing that I did not mention earlier when I was talking about the 15 or more employees is that in addition to having 15 or more employees, it is necessary that the employer be engaged in industry affecting interstate commerce. Now, I flag this because that is, in fact, the statute, but that's virtually always going to be satisfied. Because let's say that I happen to have a factory, and all of my supplies come from other Texas warehouses. You know, the widgets and the gears and all the things that are used in my equipment. And let's assume I only sell to Texas-based businesses. But still, the trucking companies that carry my items to those Texas-based businesses may well be registered in other states. The drivers of those trucks may be citizens of other states. The people who ultimately buy those goods might be from other states. And it would be pretty unusual in today's economy to be able to have 15 or more employees and not be affected by interstate commerce. For example, it would be very surprising if really I was able to source everything from Texas-only companies, and I was really able to have a business where I only sold to Texas-only companies and individuals. So if I have 15 or more employees, it would be very difficult to imagine that I am not in a business that is affecting interstate commerce. I would say even if I were the only employee in my business, I'm probably still going to satisfy the interstate commerce requirement. But the ADA doesn't just apply to employers who employ people, but also applies to employment agencies, labor organizations. So it has a broader scope than just the employer. We will be talking in the next several slides about various amendments that have happened to the Americans Disabilities Act from 1990 until relatively recent years. It is not necessary that you know what was added in this year or that year, because obviously all the additions have happened, and there wouldn't be any possibility, even though the last edition, I think, was in 2006, all the cases you'll be dealing with happened after 2006. So it's not important to necessarily know. I think it's helpful in terms of thinking about the story of the Americans Disabilities Act to know when these changes happen. I think it helps make the pieces make sense. But again, I'm not going to test you. I'm not going to ask you a question of, when was this amendment, or what was added at this particular time. The law, with all of its components, is all I expect you to know about. Okay, so who is exempt from the ADA? Well, the first group is the U.S. government. And this makes sense because the Rehabilitation Act is still in effect. Now, as I said before, the Rehabilitation Act primarily covers the same things that the ADA covers, and so there really aren't too many differences. Also, Indian tribes, Native Americans, who are, or the tribal unit is covered. Native Americans who run businesses usually would be covered by the ADA as private employers. And we've seen this before with Title VII. We're seeing it again, bona fide private membership clubs that are tax exempt. The country club, for example. So we'll be talking about three aspects of the employment relationship and how the ADA interacts with those. The first is going to be the application process. The second is going to be helping the individual actually do his or her job. And this is, of course, the main event. This is where most of the activity is going to be. And then the final thing is something we haven't talked about so much in our other statutes because it wasn't as applicable. And that is making sure that the employee has access to all of the benefits of employment. And we'll see how that plays out with certain types of disability, how they can interfere, unless a reasonable accommodation is offered, can interfere with that employee's enjoyment of related aspects of employment. So the ADA also prohibits employers from intentionally discriminating. Now, most of the time, people don't discriminate against the disabled because they don't like the disabled. I suppose there are people who are afraid of the disabled, or there can be certain disabilities that have a social stigma associated with it. For example, HIV or AIDS can fall into that category. But most of the time, intentional discrimination happens because of misconceptions about the disability or concerns about the contagious nature of the disability. And so oftentimes education can be a big help in this area. But it is prohibited for employers to discriminate against someone simply because of a disability. Now, that's not where most of the action is here. Most of the action, most of the case law is going to be about the failure to reasonably accommodate. So this isn't going to be so much about somebody not liking disabled people and not offering them jobs. Another thing that can sometimes come up, and this one is a bit of a tricky one. These are neutral standards with disparate impact upon the disabled. You know, we talked about disparate impact in the Dothard case, Rawlinson versus Dothard, which involved the woman who was under 120 pounds and she was denied employment as a prison guard. And because she weighed under 120 pounds, and the court ultimately held that a weight requirement of 120 pounds had a disparate impact upon women, because relatively few adult men are going to weigh less than 120 pounds, but a relatively significant number of women will weigh less than 120 pounds. And so similarly, we can see that a policy can, on the face, appear neutral, but can disparately impact disabled individuals over non-disabled individuals. For example, only hiring people of a certain height. Well, if I'm in a wheelchair, I'm not going to be 5 feet tall. I'm going to be whatever my sitting height is. And so under those circumstances, a height restriction might have a disparate impact upon me. That's just one example. We'll talk about how this plays out in somewhat more complicated situations later on in these presentations. Discrimination as a result of barriers of job performance that can be fully overcome by reasonable accommodation. This phrasing is a common one, but I find it misleading, and so I'm going to instead focus on the reasonable accommodation, because it's really not discrimination not to give a reasonable accommodation. In fact, you can say, and I don't mean this in an unpleasant way, but you are actually discriminating by giving a reasonable accommodation, because you're giving something more to one person. You're discriminating in favor of the disabled person. It's a good thing that you're doing. It's a legal requirement that you're doing. But remember, we talked before about how discrimination works. Discrimination is just making distinctions between people and potentially treating them differently. It's discrimination for me to give one student an A and another student a B. I am discriminating based upon the quality and quantity of the work that the A student submitted versus the B student. That's my job to do. And so all of us discriminate all the time. When you're in the grocery store and you pick this can of green beans over that can of green beans because one can has more salt or one can is a lower price or whatever the factor is, that's a type of discrimination. So when we talk about discrimination, we're oftentimes meaning discrimination for an unlawful or unfair or unkind reason. And in this situation, we are discriminating, but we're actually discriminating in favor of the disabled. And that's a good thing. For one thing, it's a legally required thing. For another thing, it helps level out the playing field that was unequal, was unfair because of the disability beforehand. Now, some circuits have expanded the ADA to also cover harassment situations, disability harassment. It's an appalling idea that someone would be harassed because of his or her disability, but it can happen. And I think that seems like a very reasonable expansion of the law. I don't know off the top of my head what the Fifth Circuit has done, which is our circuit, but I would expect that that would be the direction the law would be taking in this area. It is necessary that employers make sure that their workplace is accommodating in terms of its physical structure. Oftentimes this becomes an issue with bathroom access. Bathrooms may not have a handicapped bathroom facility. And since the particular area wasn't perhaps a public area, Title II did not necessarily apply to those areas. And so there may need to be some architectural changes, some redesign of physical space, widening of hallways to reflect the needs of a wheelchair user, the need to lower sinks perhaps in the bathroom, the need to install ramps and or elevators in places. Those things can be a requirement to make the workplace accessible. Remember, we talked before about making sure everyone has access to the benefits of employment. Well, if you can't go to the ladies' room or men's room, that's a pretty big deal. That's going to affect your enjoyment of work, obviously. If you can't get to the break room to have your lunch because there's a set of stairs there and you are a wheelchair user, well, that's a major issue. Not only are you not able to eat in a comfortable place, but you may not be able to as easily socialize with your coworkers. And so all those things can affect the enjoyment of the workplace, even if they don't directly affect the work period of time. Let's talk about associational discrimination. We've talked about this with Title VII. If, for example, a Caucasian man marries an African American woman and finds that he or she, or excuse me, he in this case, because he's a man, is being discriminated against work because of his association with his wife, that is a protected category. Or let's say the man adopts a Asian child and is subject to discrimination because of that. Again, associational discrimination is protected. Even though he himself is Caucasian and no one has a problem with him being Caucasian, it's his association person in a different group. We have that same issue with the Americans Disabilities Act. If I am in some way associated with a disabled person, I can't be discriminated against on that basis. I'm not, though, entitled to a reasonable accommodation. So let's imagine that I have a disabled child. This child needs lots of physical therapy, lots of medical visits. My employer is not required to accommodate my need to be off to take my child to these various and sundry appointments. I can't be discriminated against because of my relationship with my child, but I'm not entitled to reasonable accommodations because of his or her circumstance. Now, it is true that the Family and Medical Leave Act might provide some help in this area. But keep in mind that only kicks in after I've been employed a year. So I have to get to my first year anniversary before I'm going to enjoy those protections. So it's important to remember that association protection exists, but the reasonable accommodation part, which is the heart of the ADA, doesn't apply. So let's consider this scenario. Bob has applied for a job. During the interview, he mentions that his wife has leukemia. That's almost certainly going to be considered a disability. We'll go through it when we look at the definition of disability. We'll see how it's covered, but it certainly seems like a disability. He has excellent credentials, but he is not given the job. If he was denied the job because of his association with his wife, who is a disability, then he could have an associational disability discrimination claim. Now, if he were to have been hired, he wouldn't be entitled to more time off, but he would be protected against discrimination because of his association with his wife. So in 2008, I'm sorry, and you don't need to know this year, but 2008 was the year that a very significant change to the Americans Disabilities Act happened. And this is kind of similar to the Lilly-Ledbetter Act and also the Civil Rights Act in 1991. The U.S. Supreme Court issued some decisions relating to the Americans Disabilities Act, and the Congress disagreed strongly with those decisions and passed a statute to make those decisions no longer legally relevant. And so that's the history of how we got to this particular amendment. What the U.S. Supreme Court did through a series of cases, and really it was two, I guess, Sutton and Toyota Motor Manufacturing, was to define the term disability in a rather narrow way, so that there were several kind of hurdles that a person had to cross in order to demonstrate that he or she was disabled. And several people who might have fairly significant health issues weren't meeting that definition of disability. Well, Congress said, look, we intended for this law to have a broad scope and to cover relatively more people. And so we're going to amend the Americans Disabilities Act to overturn these bad decisions, in our opinion, of the U.S. Supreme Court. Let's first of all consider the term mitigating measures. This is one to go in your Quizlet. So mitigating measures are measures that mitigate, naturally, and we talk about mitigation when we talk about reducing damages. So an example of a mitigating feature could be wearing a hearing aid to improve your hearing. And what the U.S. Supreme Court said is, well, when we're evaluating whether somebody has a hearing problem, we're going to see what appliances or medications that this person might be taking that would help him or her avoid that. And if the hearing aid fixes so much of the hearing problem that the person has relatively little hearing problem left, well, then we're not going to consider that person to be disabled. We're going to consider the mitigating measures. Similarly, if a person's a diabetic, but once he or she takes his or her insulin, the diabetes is no longer a major factor in this person's life, then that mitigating measure is going to remove that person from consideration as having a disability. So that's what Sutton said. But the Congress said, oh, no. You cannot consider mitigating measures. So we have to consider that person with a hearing problem, which metaphorically, take away his hearing aid. Well, how is he going to hear now? Well, he can't hear much, so he is disabled. We're going to metaphorically take away the insulin from the diabetic. How is that diabetic right now? Diabetic's in bad shape. The diabetic needs the insulin to live. And so in that situation, that diabetic is clearly disabled, even though in the real world, they're going to have their insulin, they're going to have their hearing aid. So we don't consider mitigating features when we try to decide whether a person has a disability or not. The one exception is we do consider eyeglasses. So if when I put my eyeglasses or contacts on, I can see reasonably fine. When I take them off, I'm legally blind, then I'm not going to meet the definition of disabled under those circumstances. So that's the only mitigating measure that we are allowed to consider after 2008, when this particular law was passed by the Congress. Another important law, or a U.S. Supreme Court case that the Congress overturned by this amendment, was what the term substantially and major mean in the context of the ADA. And the U.S. Supreme Court said that these were pretty high hurdles, that substantially had to be a pretty significant problem for the ADA to kick into, and that major applied to pretty significant body processes. But again, the Congress said, no, we don't want these terms to be roadblocks to a significant number of people receiving protection under the Americans Disabilities Act. So you might think of it like this. The U.S. Supreme Court considered this many people to be covered by the Americans Disabilities Act. Congress wanted it to be this many people. And so by redefining the terms in 2008, the definition expanded to all of these people, not just the people that the U.S. Supreme Court had decided in Sutton and Toyota Motor Manufacturing were covered. Okay, so now we have the definition of disability. We're going to be spending a lot of time with this definition. You'll see it on several other slides as we go forward. So let's see it for the first time now and realize that we're going to see it many, many more times. So the term disability means a qualified individual. We already talked about that part of the definition. And now we're going to talk about our three situations here. Okay, so a qualified person who meets any one of these. So you just have to meet one. You might meet more than one, but you just have to have one. The first one is by far the most important. This is the rock star of this particular category. So a qualified person having a physical or mental impairment that substantially limits one or more major life activities of the individual. Now, when they say mental, they are referring to, or the statute is referring to, intellectual impairment as well as psychiatric impairment. And then, of course, physical impairment is also covered. We're going to talk in the next few slides what we mean by impairment in more detail. The second category is having a record of such impairment. This record can be accurate or inaccurate. Somebody can think this person has a record of an impairment that that person really doesn't have. Or perhaps in the past, someone had had the impairment. They had moved beyond the impairment. Perhaps the impairment was cancer or something like that. Even though this person is cancer-free and has no disability now, that history of cancer can't negatively impact the person because of the Americans Disabilities Act. And finally, and this is kind of similar to number two, number three is being regarded as having such a disability. And oftentimes that's the reason why the record of such an impairment, why people rely upon it, because the idea is, oh, you got cancer once, maybe you'll relapse, or you had this situation come up before, maybe it will come up again. And so sometimes the feeling is that the person really isn't fully recovered. So being regarded as having an impairment, whether the person has it currently or not, can also satisfy the requirements of the Americans Disabilities Act. Now, I'm going to be honest with you, we're going to spend virtually all of our time on this first category. So this is the one that's the most important in terms of just numbers of cases. But these other two are important. And you'll see that the term that people use for these three categories are the three prongs. Kind of like the prongs on a fork, one of those old-fashioned forks that only have three prongs. You can think about that. This is prong 1, this is prong 2, and this is prong 3. So let's talk more about impairments. So what is an impairment? This is the definition that we see in the statute. So we have any physiological disorder or condition affecting one or more of the following body systems. You can see there's a list, and there are lots of these. And you might, as you're going through some of these, you might think to yourself, well, how does reproductive relate to employment? I mean, unless you're being hired as a sperm donor or a gestational donor or something like that, that can't really affect the course of employment. Well, the important thing to remember is that the disability definition doesn't relate just to employment situations. For example, let's say I'm infertile. It doesn't affect my work, obviously. Let's say I have an office job. I'm a paralegal in a law firm. Obviously, whether I'm fertile or infertile is not going to impact the quality or quantity of my work. But I may need time off from work to address my infertility, to receive fertility treatments or surgeries or other things to address that issue. And so a reasonable accommodation that my employer might need to offer me is time off to accomplish those tasks. So keep in mind, impairments don't have to do with things that are going to be directly relevant to the workplace. Now, so we need to have an impairment, so one of these categories, and that impairment has to substantially limit one of life's major life activities. So again, as we saw in the the amendment to the law in 2008, an impairment does not need to prevent or severely or significantly restrict a major life activity to be considered substantially limiting. So while they didn't make substantially limiting go away, they took a lot of its kind of forcefulness away through these amendments. Another thing to keep in mind is that if a person has two or more disabilities, or two or more conditions, we'll say, none of which are especially serious, but in combination, they might substantially restrict a major life activity. We can combine those those conditions or impairments to satisfy the disability requirement. So let's consider this scenario. Bob has a mild intellectual disability on its own. Actually, I'm not going to say disability, I'm going to say impairment. On its own, it doesn't meet the definition of disability. He also has a mild form of attention deficit disorder. Again, on its own, wouldn't meet the definition of disability. But these two conditions in combination could. He applies for a position. He is not hired because the employer thinks that his impairments might be too much, and so the potential employer does not reasonably accommodate the impairments. Well, in this situation, it's very possible that even though each one of these impairments on their own were not sufficiently significant to be a disability, in combination they could be. It's going to be rare that an employer should say, oh, that's not serious enough. I mean, there will be sometimes, for example, very short conditions of short duration. It's certainly not impossible that a condition is not a disability. Your garden variety, head cold, flu, the vast majority of broken bones and sprained bones are not going to meet the definition. But a chronic condition that's going to extend more than 6 months, in most cases, that's going to be considered a disability, especially after 2008. So now we've covered kind of our introduction to the Americans Disabilities Act, and we're going to dive into the prima facie framework. We've seen this framework before, and it's very, very similar to what we'll be seeing in the Americans Disabilities Act. So the first thing that we need is we need the person to be in a protected class. Again, this is what we saw in Title VII. You had to be a member of a protected class in order to be protected. You had to prove that for the prima facie case. Here, the employee has to prove that he or she has a disability. Now, I would always say when we talked about the prima facie case under Title VII and also the Age Discrimination Employment Act, I would always say this first requirement was pretty much easy peasy. Almost no one attempted to refute the protected status of a person under those statutes. Under the Americans Disabilities Act, though, this is a pretty major category that we do consider. Now, after the amendments in 2008, this was a less common area for employers to spend a lot of time contesting, but still there is some contesting here. And certainly a person who has a more trivial condition would not meet this definition. Because this is the prima facie case, we're talking about the employee proving this, not the employer. So the employee has the burden, the employee has the burden for all of these things. The second thing is that he or she is otherwise qualified. Again, this is straight from the Title VII prima facie case analysis. Now this one is the different one. So we're going to save this one. So we're going from 1 to, now we're going to go to 3. He or she suffered an adverse employment decision. Usually it's going to be a termination or something along those lines. And then finally, this decision was based upon a discriminatory motive. And again, discriminatory motive is perhaps not the best way of thinking about this, because we're really not talking about somebody having an evil intention toward this person, because most of these cases are going to be about reasonable accommodation. So it's more that the reasonable accommodation was denied, not so much that the employer was trying to mistreat a disabled person. So let's go back up to the one that I skipped. This is the one that doesn't parallel what we had under Title VII. Again, this is more like what we saw under the religious discrimination, which of course is part of Title VII, but it's kind of the exception to the Title VII usual analysis. So if an accommodation is required, that the accommodation was reasonable. And now we have, the employer's adverse employment action was failing to reasonably accommodate. And so that decision was based upon, whatever the adverse employment action that happened was based upon that failure to reasonably accommodate. So this is the extra element that we have under the ADA. It's not new to us because we had it in religious discrimination, but we'll see that this burden here is significantly more demanding. And here we see the same analysis that we had. This is just a different way of looking at that analysis. So this is basically the same thing that we have here, here. So you may recall the ping pong ball. The employee presents the prima facie case, then the ball is in the employer's court. So the burden shifts to the employers. And in this case, the employer has to establish a legitimate, non-discriminatory reason for the employment action. For example, the employee, nothing to do with his or her disability, the employee didn't do a good job, wasn't as productive as he or she should have been. And then, of course, the employee is going to have the ability to rebut that, say that that was a pretext, whatever reason it was given. We talked a lot about BFOQs when we were talking about Title VII. Those are the bona fide occupational qualifications. We talked about, we were talking about Title VII, that you can have those for national origin, sex, and religion, but we can't have that for race. We also cannot have a BFOQ for disability. You can have a BFOQ for age too. So now we're going to talk about our key ADA concepts. This is really going to be a vocabulary lesson. We're going to go through lots and lots of terms. When we go through these terms and afterwards, please have these terms handy so that you are constantly referencing these, because this is a definition-dense topic, and you'll do better on the material if you have those terms available for you. Okay, so let's look at what prohibited types of things are in this category of disability discrimination. So we can't limit, segregate, or classify a job applicant or employee because of the disability. So we shouldn't segregate a worker because of a particular disability status and have them work in an isolated area in which they aren't able to be with their colleagues. Now, again, there may need to be some physical changes to the workplace a change to how the workplace is configured, but it shouldn't be done in a way that would be isolating. The employer should not use standards that discriminate against disabled individuals. For example, requiring workers stand up for the Pledge of Allegiance at the beginning of the workday. Well, a person who is disabled might not be able to stand safely. And so under those circumstances, to require that person do it, even though it's a neutral standard, it would have a disparate impact on, say, wheelchair users. Excluding or denying equal jobs or benefits to a qualified applicant or person because of a known disability. Again, that's pretty much a working definition. Using selection criteria that tend to screen out or do screen out individuals with disabilities. We'll see some examples of these later, but a kind of a classic example is to have a written test that, say, for a job that doesn't require a lot of reading. Maybe it's a job involving food safety, or let's say it's a cook job. And obviously it's important that a cook know the food safety rules. But the cook doesn't need to be a great reader to do his or her job of cook well. But this employer says, well, we're going to give a written test about food safety to this person to make sure that he or she knows the rules. Well, let's say a particular cook applicant doesn't do well on the test. Well, he or she might be very familiar with what the food safety rules are, but he or she has a problem, learning difference such as dyslexia that makes it difficult for him or her to process the written word. So he or she knows how long to cook the food, or how to clean areas to keep things safe, but doesn't know how to interpret the words on the paper to respond to those questions. Well, since his job doesn't require that he be or she be a reader, that would be a selection criteria that tends to screen out. An alternative could be that someone could read the test aloud to the candidate, or the candidate could verbally explain the rules, and that would be a way around that problem. Okay, failing to select or administer employment tests to ensure, oh, well, this is kind of the same idea, some more specific example of the example above. Okay, so this is that same definition we saw before with the three prongs, 1, 2, and 3. If you don't yet have this definition in your Quizlet, please add it. And again, it applies to the person's whole life, not just to his or her work life. So the impairment, such as infertility, could still be a disability. Correctable, again, this goes to the mitigating factors issue, are also covered. We consider the pre-correction situation before the person puts in the hearing aid, before the person is given the medication that sustains his life. Again, the one exception are eyeglasses. Okay, so let's talk about weight-related disabilities. Probably only morbid disability is going to be covered as a disability. Morbid obesity is going to be covered as a disability. Simply being overweight, or even meeting the technical definition of obesity but not reaching the morbid obesity threshold, that person is not going to be disabled. Now, of course, the person could be disabled for another reason. Maybe the obesity is a symptom of a larger disability. But that condition in and of itself is not enough to be considered a disability. So Mary is a kindergarten teacher. She suffers from obesity, and she's not able to safely use the chairs that are provided in the kindergarten classrooms where she works. Mary requests a different chair, but her employer refuses. Mary is going to be protected, but only if her disability is due to a physiological condition. If she is disabled but can't trace it to another condition, then she isn't going to be able to successfully request a reasonable accommodation. Now, nothing stops the school from giving her the chair. And so many times employers will, even if the condition doesn't meet the definition of disability, but the employer isn't required to accommodate under those circumstances. Perception disability is also covered, and this includes disability plus situations. Sometimes a person might have more than one condition. Again, we use the example of Bob, who has some intellectual limitations and ADHD, and both of those separately wouldn't qualify, but together they can. You might have a situation where Bob is an insulin-dependent diabetic, and he also has a mildly elevated blood pressure reading. Mildly elevated blood pressure reading probably doesn't meet the definition of disability, but it could be a disability plus situation. So it could be that the employer says, well, we're not going to hire somebody who is an insulin-dependent diabetic and who has elevated blood pressure. We might be willing to hire someone with elevated blood pressure. We might be willing to hire an insulin-dependent diabetic, but not a person with both. Well, in this case, our candidate only has one disability because the blood pressure isn't a major issue. But because it's a disability plus situation, the ADA would apply and protect that particular person. Now, again, the plus, if it isn't a disability, isn't going to be entitled to reasonable accommodation. So that disability plus person isn't going to be eligible for reasonable accommodations relating to the slightly elevated blood pressure reading. But he or she would be entitled to the lack of discrimination because of the disability plus situation, and he or she would be entitled to reasonable accommodation to the disability, in this case, the insulin-dependent diabetes. We talked about this. So as a result, in 2006, the number of disabled people went from something like this to something like this. Significant increase. So here are some examples, and these are the types of things you would kind of expect that would be disabilities. Blindness, deafness. And again, these wouldn't have to be complete. Complete blindness, complete deafness. So intellectual disabilities, missing limbs, mobility requiring the use of a wheelchair, autism. Again, somebody on the spectrum might be considered disabled. It's possible that a person who, depending upon their spot spectrum, might not be considered disabled, but in many cases they would be. Cancer, again, most cancers would be. Very simple skin cancer might not be. Cerebral palsy, diabetes, epilepsy. We'll return to HIV AIDS in our next slide, but that would certainly be covered. Multiple sclerosis, muscular dystrophy, major depressive disorder, bipolar disorder, which is sometimes called manic depression, and post-traumatic stress disorder, PTSD, obsessive compulsive disorder, OCD, schizophrenia. Those are examples of disabilities. This is just a partial list. There's lots of other conditions that meet these definitions. You don't need to commit these to memories, but these are good examples. If it's a condition that is similar to these, very likely it's going to be a disability. So let's talk a little bit more about HIV and AIDS, because this is treated a little differently than some of these other conditions. Okay, so in our other situations, we've talked about how you need to actually have an impairment. But a person who is positive with an HIV test may not have any symptoms. He or she may feel very healthy and not have any compromised health, at least at this point in the diagnosis. But this person is still treated as if he or she is disabled. Similarly, obviously, somebody who's actually in the midst of having symptomatic AIDS. Now, these positive test HIV individual who isn't experiencing symptoms, you could say that he could be or she could be regarded as disabled. But even if the diagnosis is a secret, and the only reason the employer knows is because the employee has shared the information, it still is eligible for reasonable accommodation. So we've treated HIV a little bit differently than we've treated all the other conditions. Just be aware of that as we progress in this module. So let's consider Bob. So he works for the airline. He's confided to a colleague that he is HIV positive. The news gets around. His coworkers are afraid of him, won't talk with him. He's abused by them verbally. He gets fired. Under these circumstances, he definitely has a claim for a hostile work environment and also for being dismissed because of his HIV status. So let's talk about some particular conditions that are excluded from the definition of disability under the Americans Disabilities Act. So we'll see several sexual-related conduct situations: transvestitism, transsexualism, pedophilia, exhibitionism, voyeurism, gender identity disorders not resulting from physical impairments, and other sexual behavior disorders. So so if someone is intersex, for example, and that's the old-fashioned and not appropriate term for it, that I'm going to share it so that you know what I'm talking about. Hermaphrodite. That's so the preferred term now is intersex. So a person who is intersex, meaning that he or she has ambiguous genitalia, that person would be covered as a disability and would not be considered to have a gender identity disorder not resulting from physical impairments, because in that situation, there is a physical impairment that is at the heart of that particular condition. Also, the person who is experiencing this condition, if they've had a physical impairment, for example, an injury that has caused them to have a gender identity disorder, perhaps part of their anatomy had to be removed because of cancer or because of some kind of injury, then that person could potentially be covered with by the ADA. Now, we've talked about gender identity and sexual orientation before. The ADA expressly excludes those from coverage, but they are now covered because of the Bostick case, the U.S. Supreme Court case, under the term sex in Title VII. But of course, there's no duty to reasonably accommodate sex under Title VII. So there is no duty for an employer to reasonably accommodate sexual orientation or gender identity / transgenderism in the workplace. That doesn't stop an employer from doing so if it wants to, but it's not a requirement. And so this is one of these areas where we're not quite sure exactly how this is going to play out. So you can't discriminate against somebody who's transgender, but let's say somebody would like time off for gender reassignment surgery. That seems like it might be a reasonable accommodation. We'd have to see how the courts handle that issue under the term sex in Title VII. So there's, again, still questions about how gender identity and sexual orientation will play out in terms of protection. We see some psychiatric issues like compulsive gambling, kleptomania, which is compulsive theft, pyromania, which is compulsive fire setting. Those are also excluded from the ADA disability. And again, probably pretty obvious why you'd want to have these excluded, because they would potentially be quite dangerous. And psychoactive substance use disorders resulting from current illegal use of drugs. We'll see, I'll give you a preview of what we'll be talking later, but you'll see that current illegal use of drugs is not covered as a disability. And so conditions that stem from that current illegal use of drugs are also not going to be covered. Now, a person might continue to have some disorders relating from past illegal use of drugs, and those can meet the definition of disability. So a really important word here is current. And when current becomes past is not really well defined in the case law. If I used drugs yesterday, is that current use? Probably so. If I used drugs for the last time 365 days ago, is that current? Probably not. If it was a month ago, is that current or not? We're not sure. So lots of interesting issues along those lines. Again, we already said that homosexuality, bisexuality are not impairments or disabilities under the ADA. Again, though, they are a protected category under sex under Title VII. So let's consider some other differences that people have. One can be hair color and eye color, not disabilities. Obviously, problems with eye color, I mean not eye color, but with vision can be a problem. Left-handedness is not a disability. Unusual height, that is tall or short, is not considered a disability. Again, within normal ranges. Now, somebody who's very tall and somebody who's very short usually has some kind of condition. And that condition, whatever's caused the unusual height or lack of height, then that is probably going to be the source of the disability. Also, weight and muscle tone. Again, if it's within the normal range, even if it's somewhat near the bottom or the top of those range, are not going to be considered a disability. Having a predisposed a tendency toward an illness or disease, but that has not yet expressed itself. For example, I might have a family member who had, or several family members who've had breast cancer. I myself do not have breast cancer, so therefore I am not disabled. Now, of course, if my employer assumes I'm going to get breast cancer because of this and regards me as having it, I may be covered under the third prong, but I do not actually have a disability at this point. Pregnancy is also not considered a disability. Again, we have protection for pregnant individuals under the Pregnancy Discrimination Act, which is an amendment to Title VII. Also, if a person has longer service, at least a year of service, they're likely to be covered under the Family Medical Leave Act, which we'll talk about in more detail in later modules. Personality traits such as poor judgment or quick temper. Now, where the line is between having poor judgment and having a psychiatric condition, or having a quick temper and having a psychiatric condition, can be a very tricky thing to evaluate and seeing these connections. So this isn't, the way I phrase this, I make it sound like it's the easiest thing in the world to tell where one ends and the other begins, but of course that's not the case at all. And this is an important one. Poverty is not a disability. Lack of education is not a disability. A prison record is not a disability. So if the reason that the person can't read isn't dyslexia, but is they never learned to read, that's not a disability. If a person doesn't have relevant experience because they were in prison, that's not a disability. So it's important to find out whether there is a genuine medical connection to the particular dysfunction that the employee is experiencing. We do not have reverse ADA discrimination claims. So if I am mad that I don't get as much time off as Bob, who's disabled, gets, and I happen to be able-bodied, I have no legal basis to say I should be getting what Bob's getting, because I'm not entitled to reasonable accommodation. It is the case that we will see sometimes that non-disabled people lose jobs that they ordinarily would have gotten, and that the disabled person is able to get the job before the non-disabled person. And the law does not provide a remedy for the non-disabled person under the circumstances. There really is no claim that that non-disabled person can advance, at least not related to disability. Now, of course, if that person is, that person can advance a race claim or an age claim or a religion claim or something along those lines, depending upon the particular circumstances that that person is seeing. Okay, so we're back to our three prongs. We've already seen this definition several times now. And we're going to go through these three prongs in reverse order. So we're going to first of all look, because again, the qualified individual just needs one of these prongs. This is an or situation. So we're going to look at this first one. When the qualified person is being regarded as having an impairment. Again, a physical or mental impairment that substantially limits one or more major life activities. So we're going to call this perceived disability, regarded as disability. So those who are mistakenly believed to have a disability are protected. We saw this with national origin discrimination. Remember the case it was the Conroe car dealership where the individual was from India. Well, everybody thought he was from the Middle East. And so they started calling him offensive terms relating to the fact that they thought he was an Arab. Well, he wasn't an Arab. So they were mistaken in his national origin, but they were still discriminating against him. And so under those circumstances, it doesn't matter whether the discriminators were mistaken in their belief. What matters is they were discriminating. Similar idea here with ADA perceived disability discrimination. Doesn't matter if the person's not really disabled. What matters is was the person being treated adversely because of the disability. We already talked about transitory impairments. Usually we think in terms of something that lasts less than 6 months would not meet the definition. So if an employer says, well, we're going to fire you because you broke your arm. That's not going to be a perceived disability because a broken arm is going to mend in less than 6 months. And so while that employer is not a very nice employer for dismissing someone under those circumstances, the person has not violated the Americans Disabilities Act because they haven't perceived him to be disabled. They've just perceived him to have a broken arm. Well, a broken arm would be a transitory impairment, and so that would not meet the definition of a disability. Significantly disfiguring scars can be considered a perceived disability even if the person doesn't have any impairment. The scars themselves aren't limiting that person. So in this situation, Lucy was scarred as a child. She applies to work as a cashier at a grocery store. The employer doesn't want to hire her because he's concerned about how the customers will react to Lucy because of her scars. Under these circumstances, the grocery store has discriminated against Lucy because she is able to perform her job. The fact that she has scars is not going to impact her ability to run a cash register. Now, because Lucy or anyone else who's a perceived disability isn't actually disabled, there isn't any need to reasonably accommodate that person. So the person isn't entitled to reasonable accommodation under those situations. So here are 2 examples. An employee with controlled high blood pressure, is assigned to a less desirable job due to the employer's incorrect belief that the new job would be safer for the employee. Now, I would say that most of the time high blood pressure is controlled by medication. And so you have to consider the high blood pressure without the mitigating factor. And so if you think, well, if that person who has controlled blood pressure suddenly lost access to the high blood pressure medication, most likely the blood pressure would no longer be controlled, and so therefore the person would have a disability. So this is a little bit of not the best example. It's one offered by, I'm not sure exactly where I got this one from, but from some source I got this one from. So this is maybe not the best example, but the concept is somebody who's got an impairment but not a disability is given a less desirable job. That could be an example of a perceived disability. Here's a mildly depressed employee. So this person doesn't have major depression disorder. The person has an impairment, but it doesn't satisfy the definition of a disability. But he or she is perceived as having a disability. So this employee is reassigned to a less desirable job because the employer is concerned that the employee will have some kind of incident. And so that employee could sue under the regarded as category under the Americans Disabilities Act. No right to reasonable accommodation, but you do have the right to not be subject to discrimination. Now we're going to look at the second prong. So we've looked at the regarded as prong. Well, see, the second prong is very similar to the third prong. This is having a record of a disability. So people who have a record of a disability, even though they don't currently have a disability, are protected under the ADA. And this arises because sometimes employees are discriminated against because of a past disability, sometimes because there's a stigma associated with it, such as mental illness, or sometimes because there's a fear that or maybe drug use, that's another one. Or maybe there's a fear that that particular condition might reoccur, such as with cancer. Sometimes people are misclassified and people think, this person might still be having this disease. Maybe they really aren't cured from this disease, and so the condition remains on the records, even though the person does not continue to have the disability. So in this situation, again, a person is entitled to protection from discrimination, but because there is not any current disability, there is no reasonable accommodation necessary. And now we're to that first prong, and this is where 90+% of the action is. So this is the most important by far. So let's just review on this. The term disability means a qualified individual who meets any one of the following: having a physical or mental impairment that substantially limits one or more of the major life activities of the individual. Okay. So both physical and mental impairments are incorporated in the definition. And again, I would add psychiatric to this list. Disability under the ADA is based upon individualized assessment. So there isn't, as you can see in the statute, I gave you a list of conditions that are routinely considered disabilities. You may recall them here. But really, other than HIV, I don't think there's any specific statute that, or excuse me, specific condition that is mentioned in the statute, because the idea is you have to look at each situation individually to consider how that particular diagnosis is impacting that particular person. And so it's not focusing upon here's a list of diseases that are covered, here's the list of diseases that aren't covered. Okay, so here, so we're still on that first prong. So a person's disability must substantially limit one or more major life activities. Let me just go back and show this to you again, because this can get tricky. One or more major life activities. So we're focusing on this language right here in our first prong. Now we're going to get more granular about that particular section. Just went too far. Okay, so here are examples of these major life activities. So I want you to, or I recommend that you add this to your Quizlet list for major life activities. These are examples, but I think they're good ones to use for your Quizlet. So caring for oneself, bathing oneself, feeding oneself, putting oneself to bed, getting up, dressing oneself, those types of tasks. Performing manual tasks, brushing one's teeth, being able to make one's dinner, pump the gas to fill the car, those types of things. That would be a second category. Seeing, hearing, eating, breathing, and speaking. Now, you wouldn't have to be affected in all of these areas. If you were just affected in one, then that would be sufficient. Concentrating, thinking, and communicating. Many times learning differences fall into this category. Working, standing, lifting, and bending. Working is an especially important one in this area. It's important to keep in mind that working doesn't apply to a particular job. So a particular employee might not be able to do a particular job because of the quirkiness of that job, but the person might generally be able to work. Well, in that situation, the major life activity of working he is not substantially limited in. So we're not talking about a particular job, but the more general concept of working. Then we have another term, which is major bodily functions. So this is, so you can either have a major life activity that's affected, for example, these, but it could also instead be a major bodily function. And we can see here brain, bladder, normal cell growth, and this is oftentimes cancer, reproductive system, and immune system functioning. So again, you don't need to have both, you just need to have either major life activity or major bodily function. The major bodily function was an addition in 2008. So here we have completed the definition of disability. We'll go on and cover the rest of these in later lectures. I thank you for your time, and as always, if you have questions, feel free to pop into my office hours. Have a wonderful day.